I can hear you. Uh-huh.
Good. Okay.
Turn around. Bad lighting. Good morning.
Hello.
There we go.
I can hear you. Can you hear me?
I can hear you. Uh-huh.
Good. Okay.
That's the rain. Turn around.
Can you see me now?
I can see you. Thank you. All right, we'll go ahead and get started. And this is the matter of Haley, and is it Downey?
Correct.
Yeah.
Haley Downey versus Bruce Newbecker. It's the date and time set for a hearing on defendant's motion to strike plaintiff's motion and plaintiff's motion regarding custody. Appearing at today's hearing via Zoom, there being no objections, is the plaintiff Haley Downey and the defendant Bruce Newbecker. We will take defendant's motion to strike plaintiff's motion first. And Mr. Newbecker, what are you asking for in that motion?
Basically, one second, something just popped up on my computer. Basically, I don't know, but either the case be just thrown out and she can file another motion, and that way I can have the proper time to gather my witnesses and exhibits and that sort of thing. Because I mean, I didn't even receive anything to do with this hearing, or not this hearing specifically, but of the motion for custody until Stacey Osborne sent it to me weeks after mediation took place. Because Haley, and I believe it was intentionally, she messed up the address and she mailed me the motion for custody. And she, I know, she, the zip code was not correct when she mailed it to me, and I never received it. So, I mean, the only reason I even knew to be in mediation was because they were messaging me on my email telling me, I have mediation, I got to pay for it. And I thought it was for a motion that she had filed previously that she didn't show up for court. And then that case was dismissed, and she, I guess, filed another one immediately after that, and I was unaware of it.
Okay, thank you. All right, so I guess, first of all, this is defendant's motion to strike plaintiff's motion. The motion in question is plaintiff's motion regarding custody. That motion was filed on November 21st, 2022. The parties subsequently had a status conference on that motion on February 1st of this year. The defendant did appear. He did, in fact, appear at that status conference, as did the plaintiff. So the court finds on that basis that defendant has been aware of plaintiff's motion since at least February 1st of this year. Again, because he appeared for the status conference on plaintiff's motion on that date. The court rules do not permit a motion to strike another motion. But even if the court were to construe them as allowing that sort of a request and taking the allegations and defendant's motion as true, the court finds that defendant has been fairly informed and was provided with fair notice of the existence of plaintiff's motion for over the past at least 2 months now. So given
that's also 3 months that I was not. That gives her a whole 3 months. That you said it was filed in November. I didn't receive it till February. So that's 3 months at least that she was able to prepare for court. And like I said, I was at the status conference. I was only there because I was receiving emails from the courts. Never once have I received an email or a piece of mail from Haley and anything to do with this court hearing. Because she's intentionally altering the addresses. That way I don't get the paper. That way I cannot have my constitutional right and be able to prepare for this. And as a result, I've been barred from entering exhibits and witnesses, and I don't see how that is fair at all.
Given the extent of notice provided to defendant, the court finds that his request to strike plaintiff's motion is unnecessary. The court further finds that a pre-hearing order was issued on February 2nd, ordering defendant to file a witness and exhibit list by February 16th. That order was served by the court on the defendant, and the defendant did fail to file a witness and exhibit list by February 16th. Because of that, a referee recommendation and order was entered on February 17th, prohibiting the defendant from offering exhibits or otherwise calling other witnesses for the purposes of today's hearing. The court finds that that was again entered appropriately and that defendant had proper notice. Therefore,
14 days to her 3 months.
Therefore, defendant's motion is denied. I'll issue a written referee recommendation and order to which either party may file an objection, provided that's filed within 21 days. And now we will move on to the plaintiff's motion regarding custody. And Ms. Downey, I'm going to swear you in. Please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? And we're going to stop right there. Mr. Newbecker, I'm gonna warn you right now that we're in a courtroom, and if you can't conduct yourself appropriately on Zoom, I'll go ahead and reschedule this for in person where we have a bailiff. But I'm not going to take foul language, and I'm not going to take any kind of.
Well, you're denying me my constitutional right to a fair, and this is not right. She has had more than enough time to prepare for this, as I have not, because she did not do as she's ordered to do by law. So you're telling me I had 14 days to enter my exhibit list and my my witnesses and all that. I had 14 days. Well, she had months. And mind you, I still have not received any of her witness list exhibits or anything. I still have to read the motion for custody. So yeah, I'm going into this blind, and I think that's beyond unfair.
Mr. Newbecker, you have the right to file an objection to my ruling. All right, Ms. Downey, please raise your right hand again to be sworn. Do you swear or affirm that the testimony you're about to give be the truth, the whole truth, and nothing but the truth?
I do, Your Honor.
Thank you. You can lower your hand. All right. Ms. Downey, what are you asking for today from the court?
I would like my daughter to be enrolled in school over here come next year. I would advise that she does finish out the school year since it is almost over.
Yeah, I have to stop you. What can you give me a specific school that you would like Nevaeh to be enrolled in?
I will stick with the academy. I do like that setup.
Okay, so you would like an order permitting you to enroll Nevaeh for next school year. Are you asking for anything else today?
I am asking for at least 70-30. And I would definitely also like to ask that Bruce doesn't get to see our daughter outside of his mom's care, and his girlfriend not to be allowed around my daughter.
Okay, so one moment. So by 70-30, does that mean you are asking for primary physical custody of Nevaeh and 70% of the parenting time?
That's correct, Your Honor.
Okay. And you're asking that none of Mr. Newbecker's parenting time occur outside of the presence of his mother, Ms. Kaufman?
That's correct.
And you're also asking that none of his parenting time occur in the presence of his significant other?
Correct.
And who is the significant other in question?
The same girl that he's been on and off with, Sarah.
Okay. And that's Sarah.
I believe that's how you pronounce it.
Okay. Okay, thank you. And what would you like to say today in support of your motion regarding custody?
Well, I have all my exhibits and stuff like that. Am I gonna present that, or you want me to just give a statement before I present all that?
You can proceed however you would like.
Okay, did you get the flash drive with all my exhibits and stuff on it?
I did not.
Oh,
So
okay,
you submitted a flash drive with your exhibits.
correct,
How
kind
am
of
I
like
supposed to receive that?
I did it at the last hearing, all paper. I put it in a manila envelope, and for some reason you didn't get that last time. So this time I put it on a flash drive in hopes that you'd get it. But I put it in a manila envelope and dropped it off at the your receptionist with your name on it.
All right, well, I will check one more time to see if I have that. So I'll go off the record briefly
I have
and
a question.
I'll one moment, Mr. Newbecker. I'll put your devices in the waiting room while I try to locate that. Mr. Newbecker, go ahead.
Isn't that something that she's supposed to supply to me as well?
I did.
I have not received a flash drive or anything for that matter. Nothing.
Let me at least just see if I have it, and we'll go from there. So I'll put your devices in the waiting room and I'll be back as soon as I can. The other device seems to be having some technological issues. It indicates that it's joining, but things happening. So I appreciate your patience. Hopefully this will work out soon. Well, so I guess what I'll do is, Ms. Downey, your device seems to be working fine. So I'll just put your device back in the waiting room and then.
Oh, he might try and rejoin.
Okay. So when he reappears in the waiting room, his device is gone now, then I'll try bringing both of you back in again at that point. Flash drive for this case. And I looked back in my file cabinet and I don't have anything in there. So I guess my question to you is, do you want me to adjourn this hearing to give you the opportunity to have those, I don't know exactly what it is, but to have that material available to use to support your case?
This kind of what happened last time, and I was still able to present it all. You know, I've waited over 2 years now, and I really would just like to, you know, get the ball rolling and proceed with today's hearing, if at all. I can do share my screen, or, you know, you'll still be able to see it if at all possible.
And you understand that it's going to be very difficult for Mr. Newbecker to follow along without him also having a copy of the materials. And Mr. Newbecker, again, are you indicating that you did not get a copy of the whatever the proposed exhibits are?
I've gotten nothing from her. Nothing.
So, Mr. Newbecker, are you asking to adjourn the hearing?
Yes.
In order to obtain whatever the proposed exhibits are that Ms. Downey is proposing to present today?
Yes, and her motion for the custody and everything else, if possible.
All right. Ms. Downey, I didn't see I mean, you filed an exhibit list and you filed a witness list, but I didn't see a proof of service of the actual proposed exhibits themselves. You're saying that you did serve those on Mr. Newbecker?
That's correct. I didn't mail it to him because it was in a flash drive in like a bigger envelope. And when I went to go pick up my daughter, I left it over there by his garage door. But at that time, his mom told me that he was being evicted. So whether she picked it up or, you know, what it was done from there, I don't know.
My mom's right here and she's saying it's
Mr. Newbecker, please, just one at a time, please.
Yes, sir.
Go ahead, Ms. Downey.
Like I said, at the time, his mom and his sister was telling me that he was being evicted. So what it was done with from there, I don't know, but I did leave a copy in one of those orange manila envelopes little flash drive. Same with you, Your Honor.
All right. Mr. Newbecker, I am going to grant your request to adjourn this hearing. And we are going to reschedule this for in person. I think given the problems we're having with proposed exhibits, that's how we need to do it. And also given some of the connection issues with the devices. So I'm directing both of you, anything that you want to present, you need to bring it with you in person at our next hearing date. Any documents, anything at all. And we're all going to look at it together because we're all going to be in the same courtroom together. Also, the in-camera interview, I'm going to adjourn that as well. It's going to be in person. And we're just going to have to do it that way because I don't think that if we move forward today, that it would be fair to Mr. Newbecker. And I don't think that it would be clear to me exactly what the information is, because I don't think I would be able to understand it through this format. So because of that, I'm going to adjourn the hearing. We will reschedule it as soon as possible for in person. Again, the in camera that was scheduled for 4 o'clock will also be rescheduled for the same day. And that is what we will do. So because of that, I'm going to close the Zoom room now, and I will direct Circuit Court Administration to reschedule this for in person.
I do have a quick question.
Yes, Mr. Newbecker.
So am I still barred from entering exhibits or witnesses? I mean, more witnesses than exhibits is more what I'm concerned with. Because
Yes.
I think
You are still barred. You had an opportunity to file an objection to that order. I don't know if you did or not, but that would have been your avenue to redress that. Ms. Downey?
That was my question, Your Honor. Just
Very well.